All right. Good afternoon, everyone. Welcome to another edition of Fire Law Roundup. This is Curt Barone.
Brad Binsky.
All right. And here we go for December 5th of 2022. Brad, go ahead. Take us away.
Fantastic. So we are going to start with an issue that's, near and dear to your and my heart. In fact, I just lectured on this at one of my conferences. You lecture all the time. We're going to start with Georgia, a battalion chief filed suit under Fair Labor Standards Act for unpaid overtime. Now, let me give some background generally on this so everybody understands. There are federal laws and potentially state laws, like if you're in New York, there would definitely be state laws, but there are federal laws at issue whenever, numerous federal laws at issue, whenever anybody tries to say we are exempt from overtime. And most people think, oh, you're a fire chief, you're management, you're automatically exempt from overtime. And it's not quite that simple, sorry to say to everybody. There are generally two first initial broad standards. You have to meet a minimum salary threshold, which is not the issue here, as I'll go through the facts. And you also have to meet a job description to show that you are in one of the categories of exempt from overtime employee positions, such as management. And so we're going to go through some of those here, but here are very simple facts, more complicated on the law. And again, right now, all we have is a lawsuit filed, nothing more. So we have a battalion chief. She left the Lumpkin County Fire Department. She filed suit claiming that she was improperly categorized as an exempt employee, right? An exempt employee exempt from overtime. And she was improperly denied overtime. She'd filed suit just recently, November 30th, and she's seeking back wages for the past 3 years, not 6. So she's, the whole complaint is like it's like reading the job duties of somebody who would like to be categorized as exempt with her saying, and I don't do any of these. So as initial rule, a person is exempt from overtime, and this is really important for you because if your department says, oh yeah, they're a deputy or a chief or whatever, they're exempt by definition, by determination of their title, then you're missing the point on FLSA, and Curt will jump in on this as well. FLSA has a number of factors, not one of which is more dispositive of the issue of whether you're exempt from overtime than another. But the more, the better, the courts have said. And, the first test is whether you supervise more than 2 employees. No question she did. But here she is arguing and makes a pretty good argument just from the complaint. I don't know what the true facts are. We won't know that yet. But from the complaint, she makes out a pretty good case. We would say in law, a prima facie case, that in fact, she is nothing but a firefighter who doesn't really do management activities. She merely supervises other firefighters on the fire ground. And if you read the complaint, I'll give you a couple of the factors. She says, I am not, or I don't do, or I don't qualify. She's really just going down the list, which the Department of Labor has put out as factors to consider whether somebody's exempt or not. So she says, she claims, we don't know if this is true, her primary duty was to fight fires, rescue victims, minimize property damage. She said, claims she doesn't have the authority to hire or fire. She doesn't exercise any discretion or independent judgment. Now, let me stop here for a second. Let me go back to hire and fire. The test isn't that she has authority to hire or fire. Or she has the ability to make weighted decisions or weighty decisions that, have a lot of influence. So she only gives half. So I'm questioning, why are we only citing half of the rule? Nonetheless, she goes on and claims that she doesn't exercise any discretion or independent with regard to matters of significance. She doesn't have to have any specialized knowledge of any advanced type in a field customarily acquired or prolonged, specialized intellectual study, et cetera. So she has no specialized training other than basically being a firefighter. She would direct the work of other firefighters and rescue at the scene, but maybe not outside the scene in the management capacity. She talks about her salary, but basically she then says, listen, I should not be classified as an exempt employee. Curt, over to you.
Yeah, well, this is one of those areas that there's a lot of litigation on. I think pretty much everyone's settled on the fact that line captains and lieutenants are going to be considered hourly employees. The weight of the cases, there's a couple of oddball cases, but most of them say pretty much company officers are going to be considered hourly employees. The battleground right now seems to be on chiefs. And it's funny, I was watching some of the comments on the original story that I published the other day in social media. And the pundits, some of them are saying, oh, she's clearly an employee. She's clearly an exempt executive. And the reality is it's a lot more complicated than that. There are no simple answers here. But this has been an ongoing problem since 1985, when the FLSA really became applicable to state and local government. So prior to 1985, this was not an issue. Since 1985, it is. It got to the point where the Department of Labor actually got involved and issued a set of regulations, which are kind of affectionately referred to as the first responder regulations. And those are the ones that are really driving a lot of the decision making here. So again, a lot of legal wranglings are going to have to happen here. We have the scales of justice, and I think one way to kind of think about this is, each duty that a chief officer has can weight toward being part of management, can weight toward being a first responder. Okay, the fact that you're on a shift weights towards being a first responder. The fact that you go to fires, you dispatch, you don't have discretion. When you dispatch, you have to go. That weights towards being a non-exempt hourly employee. On the other hand, the fact that you are involved in management type decisions and other types of things weights on the other side. So how this is all going to weight down, no one in social media knows. Okay, it really, you're going to have to go through depositions, requests for productions, in
job descriptions, civil service records, whatever.
But I think the way I like to do it, because this stuff sometimes gets emotional to firefighters, because if you're a chief and you feel like you're watching captains and lieutenants make more to you, you made battalion chief and you're watching captains and lieutenants make more to you because they're getting overtime, there's some frustration that can set in. So I think it's helpful to kind of think about this from a different profession. Okay, and one or professional business, and I like to use Home Depot, okay, since it's one of my favorite stores, okay? But you think about the CEO of Home Depot is clearly an exempt executive, no question. His job is managing the enterprise, okay? The manager of an individual store is an exempt executive. Now, they're not the owner of the company or whatever, but they're okay. So now let's kind of drill down. How about the person who is in charge of hardware? Is that person an exempt executive? And we start looking at, well, do they have the ability to hire and fire? No, that's the store manager. Okay, so there's something that weights, okay? Do they have the ability to make decisions on matters of significance, such as where are we going to set things up? What's going to go on sale? Nope, that's the job of the store manager. And you start looking at all those and you put all those different factors in the different scales. Do they go on the management scale? Do they go on the hourly employee scale? And when all of the fact finding is done, then the judge has to weigh both scales and see which one weighs the most. Are they more managers? Are they more hourly? And then we have a decision. So again, there's a process that folks have to go through. And I think sometimes it's helpful if we step away from the fire service, step away from the emotions and the personal connection that we have there. And we kind of think about it in a different light, and then we can kind of be objective about it.
Yeah. And I would say this, I would say if I was drafting this complaint, the lawsuit, I would have done it somewhat differently. So this is a little complicated, but it's telling as to why the individual did draft the complaint. So the individual highlights some main points of, right, well, I don't have any of these powers, so I'm not executive, but doesn't go through all of them. Just so all the viewers know, there's a long list of factors. And as I wanted to point out to people, look, she said one thing, but she didn't address the other, right? She said, I don't have the power to hire and fire. That's not the whole test. Or do you have the power to make heavily considered decisions? She never mentions that. So the way I would be drafting a complaint, a lawsuit, is I would do it in one-line sentences. I'll explain to everybody, but again, this is telling to me that there's more to the story. I would be doing one-line sentences of the allegations, and I would not combine them. I would do them each in one line. And that way, the employer is going to come back and has to admit or deny each single statement. So they can admit or deny, and then that should make the facts pretty easy. They admit I have the power to hire and fire, or they deny I have the power, or they agree I don't, right? And then I would have gone through about the 40, I have a list, there's about 42 different factors that I go through. And some are, you can do this, or you can do a combination of these things, right? There's a ton of factors, and they come mostly from Department of Labor opinions and decisions. And clearly, as we both said now, not one matters. It's a conglomerate. But what's irking me in the back of my mind is, why didn't they address every single factor and not just half the factors? Because this is a lawsuit. And while some lawyers do what's called general pleadings, notice pleadings, they don't give all the facts. This is the type of lawsuit that requires you really to give all the facts. And they didn't do that. So there's something twinging in the back of my mind saying, don't jump to an opinion so quickly. We only have half the facts. I just, as a practitioner, I just wanted to throw that out, that I wouldn't have proceeded this way if every fact went in my, weighed in my favor. I would have gone through all the facts, not just 4 or 5 different factors. There's a lot more that weigh in.
Well, for those who want to know more about the FLSA as it applies to the executive exemption and really anything related to the fire service here, we're going to be having our next FLSA for fire departments program. Starts tomorrow, December 6th. We're doing it a little differently than we have in the past. We're doing instead of doing 4 days in a row, 4 6-hour days in a row. When we do it live in person, we do it 3 8-hour days, but you do the math, you can do 4 6-hour days. So that's how we do it when we do it online. And rather than do it 4 days in a row, we're going to do it a total of 4 days. We're going to do Tuesday, Thursday this week, Tuesday, Thursday next week. We call that the 2+2 schedule. And the idea there is that many of the people who come to the classes are either payroll people, finance people, chiefs, union presidents, and so on. They just can't take 4 days in a row out of the office. And plus you're in your office, people are calling you, you're going to meetings and all that. So bottom line is, what we do is we break it up. So you can go to the class on Tuesday. If you miss some, you can watch the recording, go to the class on Thursday, all caught up. Then you have a couple of days to catch up on anything you missed and right on through. So, but again, that class starts tomorrow, December 6th.
Very good. Okay, next one.
Next case.
Let's go to the Court of Appeals holding in Illinois. I'm going to plead some head-scratching confusion on this. I got to tell you, I don't really understand the issue. I understand the legal issue. I don't understand what the heck. So here we have that the Appellate Court of Illinois. Now, let me just start with, first, this issue went to an administrative tribunal. Then it went to a court. The former fire chief that I'm going to tell you about lost both times, and then the Court of Appeals reverses, right? But she got through, this fire chief lost twice, so to speak. So, I always say, don't worry what happens in trial court. It's all what happens at the appellate court. So here, the appellate court ruled that a former fire chief was entitled to pension credits for 4.5 months it's a male, was on that the fire chief was on paid administrative leave prior to his retirement. And this is not so uncommon, right? Somebody goes on leave for a number of months, and then retires. A lot of times this is a negotiated retirement. I'm not saying what, led to this here, but as Curt and I know, right, a lot of times this is, listen, we want you gone, but you'll agree just to take a leave. You're so close to retirement anyway, rather than just terminating you and fighting that. We'll all agree you go on leave. And there's been a dispute. This is, back in 15, normally we're seeing things in the last few months. But it's, again, gone through a long process. The chief retired in January 4th of 16, and then immediately a dispute breaks out about, well, do we include the time you're on paid leave? And the court argues that, yes, you do, right? You do get the time on paid leave. I don't totally understand, I'm going to admit, the rationale for the court's decision, though I agree with it.
Yeah, I think it comes down to the definition of firefighter. Okay, that in order to qualify for the pension under state law, you have to be serving as a firefighter. And if you're a dispatcher, you don't qualify. You're a mechanic, even though you work for the fire department, you don't qualify for this particular pension. You have to be a firefighter. So what the folks that were overseeing the pension said, they said, look, you put in 4.5 months worth of time, but you weren't a firefighter. You were on administrative leave. Therefore, you don't qualify. Well, I think if you get into the politics of it, and again, I don't know this chief. I don't know what may not have happened, but I do know that sometimes chiefs have to make decisions that not everyone in the organization appreciates. And sometimes those people happen to get on the pension board. And so now it comes time for the chief to retire, and people are just waiting to stick it somewhere. This is the chance. So I don't know if that's going on, but I think that is certainly something that I'm thinking may have gone on in the background. They were not happy about him getting a pension. There was also the issue of him getting a pay raise on January 1st. And apparently, I know all the departments I've ever worked for, you get a pension based on your last highest year, last highest 3 years. This apparently, his pension is based on his salary when he retired, which is a beautiful thing. Yeah. But he got about a 3% pay raise just days before he would have retired. So that's going to increase I'm looking at the numbers here, it's going to increase his pension by a little over $5,000 a year. So he wanted to qualify for that. He wanted the extra time and so on. And the pension board said, no, not so fast. The state law says that you have to be a firefighter, and for those 4.5 months you weren't a firefighter. Therefore, as far as the pension board is concerned, you retired as of was it July,
August, something like that,
August 20th or August 21st. So that was the dispute, and the court did, I don't think the court did a good job of explaining it, but the court pretty much said, look, he's a firefighter. He's a firefighter. He was the fire chief. He might have been on leave, but and I think they could have used another metaphor here just to explain. But when a firefighter is on vacation,
they're still a firefighter.
They're still a firefighter, right? So what is the big deal? If
you're sick, if you're disabled, if you're pregnant, if you're anything, you're still a firefighter. And that's what I don't understand about this case. But what I don't understand is how the heck did they lose twice, right? What else are you?
The pension board had the authority to rule that way. Why the trial court, I think, gave too much deference to the pension board. And I think that's pretty much what the court said. Then they actually used it clearly.
Right, but he's on paid administrative leave, right? What are they paying him for if not as a firefighter? I don't get it. So anyway,
it is what it is. But as of right now, unless it gets appealed up to the Illinois Supreme Court, he's going to get that pension credit.
Yep. All right. So now let's go back to our, the hotbed of many lawsuits, Los Angeles. And we just have a lawsuit, but it's this is like I'll call it like a advanced discussion, or can lead to an advanced discussion on liability it's just a lawsuit, so not a court decision, but Curt, you and I can chime in with what are the legal issues. And this is a repetitive issue. Now, again, I do want to say this is what most people think most of our lawsuits are about. And as Curt, you say all the time, 70 some odd percent of our lawsuits are more about discrimination and employee issues, not dropping people. But nonetheless, this happens. So let's talk about the law on it. So the facts are, well, the allegations, it's just a lawsuit, are somewhat simple. So a woman called for an ambulance. She was in bed. She needed to be transferred to a wheelchair. I'm guessing it's like a stair chair, right, to carry her out to the ambulance. And she claims that on December of 21, she's at a residence, calls 911. The personnel arrives, see she's in bed, need to transfer her to what they say a wheelchair, but I'm again going to assume it's like a stair chair, which was 3 to 4 feet away from the bed. They said when they transferred her, they failed to support her or secure her. I'm having a hard time thinking what else could they do. It's right. Probably somebody at her chest and somebody at her legs and pick her up and move her. But in any event, she fell violently and loudly. I don't think those words serve anybody well, because it's hard to imagine they flung her to the ground, right, to slam her there. I don't know. Maybe she's, of such a weight where she made a violent and loud sound. I don't mean to be mean, but in any event, I don't know what violently dropping someone is, but that's what she claims. I don't like those types of things because they immediately paint you as a little overreacting. But nonetheless, she allegedly fractured her leg. That's, let's call facts part A. Part B is more interesting to me lawyer-wise and should be to our viewers, right? So, but as to part A, they said they were negligent and grossly negligent, which says basically you failed to act as a reasonably cautious paramedic, EMT, firefighter when you moved her, right? You didn't even attempt. Gross negligence is you failed to act carefully. Gross negligence is you didn't even attempt to act carefully, right? So frankly, I think she would lose even what she claims based on gross negligence. Maybe she wins on negligence, but for the qualified immunity. Okay, that's the part A. I hope I'm not confusing people. That's her claims part A. Her part B claims, right, the second part to her claims are that they didn't transport her. They waited for a supervisor to arrive and they delayed transport by waiting. And to me, now that calls into, okay, is there a policy that required them to wait, or did they wait, right? Or did someone say, and what was the wait? Was it 1 minute, 2 minutes? Were they loading her and treating her while they waited? So these are just allegations. We don't know anything, but it leads to a very interesting discussion on two parts. One, qualified immunity, as you and I have talked about a million times, we'll do again, and B, immunity following a policy that's not discretionary of the city or county that says, hey, you got to wait for a supervisor if there's an accident. And I'm making that up, assuming that's why, if they did wait, that's why they waited. So as everybody should know, it's a good thing that they alleged gross negligence, because in most cases, you will not win a lawsuit against a municipality if you were merely negligent. Now, I don't know what the immunity, I don't know if you know what the immunity statutes, if any, are in this case that would be at play here.
Mm-hmm. I'm not. And, whatever I think immunity, we also have that other issue of the public duty doctrine. So both of those kind of work to give us extra protection,
right? But
they're not going to protect us against gross negligence.
So that's why they allege gross negligence. But the public duty doctrine, I think, is why I separate it into parts A and B, because B is, were they just following a non-discretionary policy that says you better wait? I have a hard time believing, right, that. On the other hand, think of instances where a ambulance is an accident on the way to a scene with the patient and back. I'm aware of, and I'm not saying I agree or disagree with these policies, I'm aware of a lot of policies say you will pull over and wait for another ambulance to transfer. But usually those policies say something like, unless the life or death of the patient, requires you to keep going, and then you'll notify the police, whatever. So I don't know what the policy is. This is nothing more than allegations. We don't have to go too much farther on this, but it's two different things. But so everyone understands, if they just alleged negligence, they probably would have this dismissed, but they allege gross negligence, the failure to even act, the failure to even attempt to act carefully. And for that reason, they say gross negligence, and it may survive a motion. But this is so early in the case, this will go on forever, I'm sure. Okay, anything more on that? Or are we good?
No, I think it's a pretty straightforward. I try to provide a sampling of what the cases are that are coming in. So, there's not a lot here. It's a sort of a run-of-the-mill negligence case, nothing special, but roughly somewhere around 10% of our runs, 10% of our fire service lawsuits involve incidents, and roughly 30% of those incident-related suits come from EMS. So this is sort of representative of relatively small portion of our liability problem.
Yeah, let me just forecast. I should have done this at the beginning. Let me just forecast. The last issue we're going to discuss about beards is so super interesting. Yeah. So much so I spent a lot of time researching some background on that case. Cool. But super interesting. So if these are, not kind of tickling your interest, wait till the last one on beards, because that's going to be huge. Yeah. I think super huge. In any event, now let's go to Wyoming. A Wyoming firefighter sued, again, just a lawsuit, but a very unique lawsuit. I ultimately think loses in the end, but we'll see. Just my opinion, but sued a utility company and a contractor who were supposed to clear trees and branches from power lines so they didn't catch on fire. Well, the firefighter sues because his wife got killed as a result of the wildfire that they say would have been prevented, would not have occurred, but for the utility company, et cetera. So basically here, those are the facts. Let me give you a little bit more. He sues the Beartooth Electric Cooperative and Asplundee, whatever, I don't know how you pronounce it, tree expert, Asplund, right? And because Beartooth Electric was required by law, that's the interesting thing, to remove the branches from power lines for this exact reason, I presume. They contract with, as part of their obligation, they contract with this tree expert company, and the tree expert company allegedly doesn't do what they should have, right? And then which is removing the branches, and then the lawsuit, the fire happened, and then the wife dies in the fire. Horrible, especially it's horrible anyway, but the fact that it's a firefighter, firefighter's wife is even worse. In any event, that's the case that under Wyoming law and a contract, the tree should have been trimmed back to prevent contact. Now, we don't know anything more, but I could come up with a lot of facts. There's going to be a legal issue. There's going to be a factual issue, right? The legal issue is this, the municipality is going to try to get out of this saying, listen, we contracted with somebody. We fulfilled our duty. And then the question will be, do you have a duty to inspect their work, right? Is it a delegable duty or is it a non-delegable duty? In other words, is it a duty you can contract with somebody and that's all you have to do? Or do you can take care of it any way you want, but you are always liable? And then there's a lot of other parts to this suit, which I see problematic. I don't want to go too far down the rabbit hole. Again, it's only a lawsuit so far, but it involves a firefighter. So, the other part of the duty is in New York State, we have a case called Weiss v. Fote, and that case is about guardrails. But it says, listen, a municipality can't afford to put guardrails everywhere. There's limited resources. So unless there's some sort of urgent, known danger, you're really, we can't tell the municipality to put guardrails on every street. It has to be some danger, some obvious injury. That same type of thinking here would have been, wow, there's a lot of power lines to inspect, and you can't afford to do all of it, even though you're required to. So will something like an economic realities test protect the county? And look, you can bet on the municipality is going to go after the contracted entity for failing to do the job, or maybe because it sounds like they actually did cut the trees, just not back far enough.
Yeah, so I don't think Beartooth, if I'm not mistaken, Beartooth is not a municipality. I think it's a utility.
Oh, so utility, you're correct.
Yeah, so they're kind of going after the utility, and I would say maybe 15 years ago, even 10 years ago, we wouldn't see suits like this. But over the last 10 to 15 years, we've seen a ton of litigation coming out of California.
Yeah.
And there's basically at least one utility that's been put into bankruptcy because of wildland related lawsuits like this. I think attorneys have been kind of like attorneys did with vehicle safety back in the 70s and 80s, where at one time there were no airbags, there was no safety, there was no crash worthiness,
no doors.
And over the years, the attorneys got very good. They lost the first few hundred cases, but after filing, they get very good at narrowing the issues down, and they really forced the auto manufacturers to tighten the safety requirements on vehicles because they were going to be put into bankruptcy. So again, there was some federal involvement in that. How does that relate to wildland? The attorneys in California that have been filing these lawsuits, they lost the first few hundred, okay? But they're getting better and better and better at it. And I think people are noticing that, and they're looking at the successes that these law firms are having out there. And this is another wildland-prone area of the country out west in Wyoming. And they're going after the utility for not doing what the utility knows is creating a risk of a major wildland fire. And so I don't think this is the type of suit we would have seen 15 or 20 years ago. Today, particularly out west where there's a wildland problem, I think we're going to see these. And again, what piqued my interest was the fact it was a firefighter. Wasn't mentioned in the complaint, and I really don't know. And if anyone does know, please feel free to write into us. Was Mr. Clark, I believe, Mr. Ruth, was he at the fire? I'm assuming he was. I'm assuming he was, because he did get called to the scene. He did have to identify his wife's body at the scene. So I'm assuming he was, but the complaint didn't say that he actually fought the fire. But I think that's a nightmare that all of us have, that we're going to be out trying to save other people, and
it's one of our family members. Yeah.
Yeah.
And here, again, I would normally think that it's a public utility, so they may enjoy, I don't know the laws there, whether they enjoy some public.
It could be a quasi municipal entity.
Right.
Yeah.
But here, it although as I raise the guardrail case, right? Hey, you can't cut every tree branch back. You can't, be perfect.
Same principle.
Right. But here, something in the complaint led me to believe, or hints at me, that maybe they cut it back, but not far enough.
Yep.
Now that is good and bad. That could be the negligence performance, if there are recognized standards at how far back you're supposed to go, or if it's discretionary that, hey, we cut it back, we thought it was far enough, and hey, the wind caused it, or whatever. So I don't know about how far you cut tree branches back. I always know I drive down the street and it's ugly as heck, when you see it, but for good purpose. So I don't know, but there could be some really good defenses, motions. I suspect there's going to be a couple of motions right at the bat. This is, again, nothing more than a lawsuit, but a very interesting, as you're saying, more common than we've seen before. Okay, if we can. I'd love to get to this case. If this is our highlight case of the week, I would like to sit here and scratch my beard. By the way, a beard in which I would never for 2 seconds say at this moment with this beard, I should be an interior firefighter. But I went through this. So let me go through this slowly. And you should all be looking as well after this. I think it's called the Bay case, BEY, because that's what I'm going to weigh this against. That was the FDNY case, similar to this, where some individuals claimed that the FDNY's implementation of a no facial hair standard and no growth standard, in that case, which they won at trial court, lost at the Federal Court of Appeals. That case, the court held, I'm sorry, that's an OSHA standard, 1910-134. All right, it's an OSHA standard, and the FDNY has every right for the safety of their personnel and their victims to implement that. Now, one thing you will not see in any further of this discussion is a discussion of the OSHA standard. So let me talk to you about the facts of this case. It is head scratching okay, let me tell you how we got here. So we've got 4 people, Muslims and Jews. I'm Jewish. I don't want anyone to say, oh, you made a derogatory comment. No, I'm not. I'm speaking factually. So I'm presuming they're Orthodox Jews who are required to have a beard and facial hair and not cut it, etc. So there are 4 members of the District Columbia Fire and Emergency Medical Services. So we're in DC, right? Not Washington State. We're in DC. And they're asking a federal court to reopen, that's important, 2 religious discrimination cases that go back to 01 and 05. And I'm going to explain what they are and how they got there.
I've got some background to fill in there too. So when you get there, let me jump in.
Okay. So we go back, if you want to go back to the history, right? So prior to 01, and I'll give you 2 very short things, and it's probably a good time right after that to jump in. So prior to 01, the department said, listen, everybody needs to be clean shaven. And the rationale, to my head scratchiness, the rationale is uniformity and appearance. And they lose, saying that's not a good enough reason to have to be clean shaven. Then in 9/11 happens, where we have terrorist acts with hazardous environments. And the department again says, okay, we need to have a clean facial, clean face to wear SCBA. And they said a couple of things which I want to visit about SCBA, positive pressure masks, that blow my mind. Look, I'm going to say something and I'm going to get beat up, hopefully not by the person I'm saying it about, but I am missing something, or these are the least knowledgeable attorneys and department members ever about how they talked about SCBA and positive pressure, but I'll get to that in a second. So they lose, on the first.
Let me jump in, Brad.
Yeah,
let me jump in only because I have some inside knowledge on as to how the attorneys argued this case. And these are the first 2 cases back in 2001 and 2005, 2 separate cases. They were combined. And if you remember, after 9/11, the federal government started issuing these filter masks because they realized that we had first responders that were police officers, other types of law enforcement. We couldn't get everybody trained to SCBA. We couldn't possibly equip every unit, but we didn't know what was coming next. So they came out with these negative pressure filter masks.
And negative pressure is very important as a fact here.
Right. They were given to police officers, all sorts of different first responders. Okay. So that was issued. So now we have these 2 suits challenging the beard requirement. And apparently the DC attorneys decided that it would be easier to win this case by conceding the positive pressure issue and saying we need to make sure that they're clean shaven because we also have these negative pressure filter masks.
And they're nuts for having done it.
Absolutely disastrous for the attorneys to have made that decision. But what they listened to the plaintiffs make the argument that positive pressure masks make beards okay, which is baloney. Okay. But that was the argument.
That's what's killing me here. I can't understand it.
I gotcha. So, but the attorneys decided they made a strategic decision that we're going to win this on the negative filter mask. Okay. Then they get to the trial, the hearing or whatever. And the testimony is that never in the history of DC has anyone actually worn a filter mask. I had to wear one of these filter masks.
Enter COVID.
And what's more, because they're firefighters, unlike police officers, they're going to have positive pressure masks with them. And the bottom line is, based on that, they lost the case. They waived
COVID.
I'm sorry. No. This was all before. Enter
COVID.
Okay, but wait. So now what happened was, in the case, the judge issues a permanent injunction against a certain rule that required basically clean shaven
Right.
interface at the mask. So now we have a permanent injunction in place in DC, and now we have COVID.
Right. And the permanent injunction was based on horribly, you and I would
Flawed-
never have
flawed,
conceded,
yeah,
right?
flawed strategy in the litigation. Absolutely.
Oh my God, horrible.
Yeah.
And to say, well, fine, you can wear FCBA instead of an N95 or whatever, right? But again, even though I'm guessing probably having N95s were required on the ambulance for some purpose here as filtering masks, right? Which is crazy to me. If it's sitting an inch off of your face, it is not filtering anything. A half inch, in your case, 6 inches off your face, right? Hey, well, Billy Goldfetter would be 7, so you haven't quite got there yet.
I'm Avis. I try harder. We're number 2. We try harder.
So COVID comes and they say, hey, wait a minute, national standard. These are my words, not theirs. This would be my argument, but they say, change of circumstances, February, March now has come of 2020. We need to wear masks. Although interestingly, and we're going back and forth, remember in 2020, we need masks. Don't wear a mask. You need 2 masks, right? I mean, so it was, they were up against the wall anyway. But in any event, now they said, listen, we have a pandemic. All the rules have changed. I think that's what they're saying. Now you got to wear a negative pressure filtering mask. And so change of circumstances, pandemic. I have to say, DC should win here. How can you say you can't require masks? And I get it, permanent, but change in circumstances on a 500-year event, right? Or a 200-year, whatever we decided COVID now is, right? Nobody predicted a pandemic since the Black Plague or whatever. And the court just didn't think about it, right? And no, the court shouldn't have issued a permanent injunction, meaning forever, because there could never be change in circumstances. They did. That's what's being challenged. Now, let's deal with this in 2 parts, because the first part is now, the first part is, where do you evaluate this? Today or in 2000? You have to evaluate this back in 2000. And for damages purposes, at least, you have to go back to 2000. Whether today that rule can continue to be enforced, saying you have to wear a mask, right? And I think it would be. I think if the employer says, look, the preeminent thinking is you need to be able to wear a mask, it has to have a tight fit, and you can't fit with a Curt Verone beard here, and theirs are much bigger, by the way. They have chin, right? There's not just pushing it off their nose, because it would be over their nose, right? Yours wouldn't be a problem, obviously, but the Orthodox Jews and Muslims could have great big bushy beards, and there's no way it's sitting within an inch or 2 of them. Even if they pull it tight, fine, but there's still a gap. There's still a centimeter, whatever type gap. And universally, we accept that under 1910-134, you got to have a seal on an N95. The problem here is they use the old admissions about positive pressure SCBA, and they are ridiculous. For example, one of the things they claim in the complaint is, hey, DC admitted that there's no big deal with a non-tight fit on a positive pressure SCBA, because that just blows the air right out. Wait a minute. Assume for the moment that, fine, there's no danger to the firefighter, which is BS, because I've accidentally been in a fire with, and it has a seal, and they take a breath and some hot air comes right in and you feel it. Right? So it doesn't blow the hot air out. It may blow cold air out. But the other point is you're losing your air, right? If you don't have a seal, the air keeps flowing. I don't understand why DC made that ridiculously inane comment.
I just told you why. It was a strategic. And again, Brett, this goes back to the problem we have. We have non-attorney firefighters. I'm sorry, non-firefighter attorneys.
Yeah.
Okay. We got non-firefighter attorneys arguing a case involving the fire service in front of a judge who's not a firefighter.
Right.
Okay. And they don't understand what's fact from fiction. If you had a courtroom of firefighters, it'd be one thing. Okay, so you got these two, and they made a strategic decision, and it's crazy. But the bottom line is, OSHA has said, and they reaffirmed it in the New York case. It is the Bay case. I double checked it, right? Bay et al. Versus City of New York. That you have to have, even with positive pressure, you have to have a clean seal. There cannot be facial hair at the interface, period. So basically, DC since 2007 has been in violation of OSHA and NFPA requirements and NIOSH.
And the interesting part about the Bay case is, one of the arguments in the Bay case is that the FDNY switched from saying it's okay for the firefighters not to be clean shaven. And they alleged at the Second Circuit that the FDNY switched its view and said, well, now we require clean shaven if it takes 2 or 3 times a day, no growth. And one of the points the firefighters lost on is that the FDNY was being irrational and didn't have a true standard because it switched. And the court specifically held, the Second Circuit specifically held in Bay, that the FDNY was allowed to change its standard, was not bound by the past, and could come up to, modern times by requiring the clean shave. Now, there was no permanent restraining order prohibiting them from doing that, but I question how any judge could have issued an injunction had the issue of 1910-134 been raised. I don't think it was. And how do you not raise it for that type of mask? And even if you're talking about—
They thought they were going to win. They thought they were going to win on the negative pressure. It was a strategic mistake.
Horrible.
It's like starting out with 1 3/4 when you should have started with the deck gun.
Right.
It's a strategic mistake, but you're already committed to it now.
And to do that, they must have thought, what? The positive pressure SCBA was going to be an universal supplement for wearing a mask? Come on, we're just not doing that.
Again, non-firefighter attorneys arguing a case before a non-firefighter judge.
So we should make specific point to keep following this case. Obviously, you will, but because I got to say, the motion, I would be making a motion to dismiss based on the Second Circuit, Bay case. It is so close. It is so close. And I know it's different mask, but it's and a little bit different scenario with an injunction, but you can't have an injunction against a mandated federal activity. I don't know how you can agree to waive federal law, right? That's designed to protect all of your employees.
Well, I got 2 points. And they're going to piss off people on both sides. So, but the first one is that DC screwed up again. They should have went back and asked to have the injunction removed or quashed, or whatever the term that they use in DC would be. But here it'd be quash the injunction. Okay. Yeah. That's what they should have done back in 2020, when they first decided they needed to re-implement the facial hair. So that's, you don't just ignore an injunction. Okay, so it's possible they could be in contempt. Okay, now that's issue number one. Okay, secondly, I know a lot of my friends in DC have beards and they want to keep their beards and so on. Okay, so on the fire department, yeah. Oh yeah. DC Fire. Oh yeah. So now here's the thing. Oh yeah, they're like not liking the discussion that we're having here. So that, which is fine. Okay, but here's the thing. Okay, NIOSH, as sort of the research branch of OSHA, not the separate organization, but really OSHA depends on NIOSH to do the research. Okay, what needs to happen for the folks who want to continue to wear beards is NIOSH needs to go back and revisit this with modern research. And after that research is completed, if indeed it shows that positive pressure can be worn with facial hair at the interface, then OSHA should change the standard. But you can't do it the other way around. It's not smart, it's not safe. Okay, the research comes first, and then we change the standard. But you don't change the standard just because, for whatever reason, you feel that you want to have a beard. Okay? do the research first and then make the change. If that's what the research suggests, that's the proper way to do it. Okay. So we'll see how this all plays out.
It's going to be very interesting. Great case. I'm hoping there's a motion to dismiss. Honestly, just so we can get some quicker answers.
If I'm the judge, whether I was right back in 2007 or wrong back in 2007, I am not going to be happy that they ignored my order. That you have an injunction, you come back into me and give me the opportunity to change the order. You don't just ignore the order.
Although I think you have to, I'll give you a couple of reasons why it might not have happened. Remember what happened in 2020, March? Courts shut down, at least New York State, courts were shutting down.
But there was still the ability to get and I would have done it on an emergency. We're talking about an emergency hearing.
Agreed.
Maybe an ex parte hearing.
Right. Had they done that with the panic and the pandemonium that was happening in 2020, I think a judge would have said, sure, we're not going to, allow you to send people out without a mask. It's not their choice. But, this case addresses mandatory vaccines in some interesting ways, right? Because here we're saying the employer has the right to tell you what to do for your safety. Either the employer has that right or doesn't have that right.
Mm-hmm.
I think this case is so far-reaching because it's got to show the change of circumstances are warranted by the pandemic, by an employer's duty to provide a safe working place, by OSHA requirements, by the prior bad calculated tactics they took, whatever it is. This court has got to come out and say, because there's so much precedent on mandatory vaccines and other things, that you must allow the employer to mandate proper fitting masks. And there's no other, says NIOSH and OSHA, there's no other right now, there's no other change. There's no strip you can put in. There's no pull it really tighter. There's no alternative to clean shaven at the present time. They've got to lose, but let's see what happens. I can't
let me throw out another argument. It's kind of like what do we call a sharp practice, which my uncle always said, don't engage in sharp practices in the practice of law. That's sharp practices where you're really kind of doing something that's borderline here. But here's a sharp argument. Okay, the injunction, and I put it in the post here. It says that the defendant, basically department, the DC. The District of Columbia Fire and Emergency Medical Services, or FEMS, basically is permanently enjoined from enforcing the facial hair provisions of Special Order 20, Series 2005. Okay, so now sharp practice say, well, yeah, we rescinded that one and we came out with Special Order 21.
Right, which they say is it's the same thing. And
I get it. But if you're saying, well, we're gonna, this is the issue here is, did you violate the order? Did you ignore the injunction? They can say, well, no, we didn't. We actually honored that. We didn't enforce that anymore, but we came out with a new, I think, safety operations bulletin number 10.
Yeah. Not the same thing.
It's so we complied with your order. We just came out with a same principle, but we came out with it with a different number. So whether or not that's going to be a sharp practice, whether or not it's going to give you a colorable argument when you go back before the judge, and I'm not even sure that judge is still, he may have retired, he or she may have retired. So
yeah, and again, the whole argument's got to be COVID pandemonium. And by the way, we now know more than we do, but I'm citing Bay, and based on Bay, I'm sorry you lose.
Bay is pretty compelling. It's a Second Circuit ruling.
Very smart court. Second Circuit's very well respected. They're a smart court, and I think they're going to be heavily influential if this goes, to the appeal. But at the district level, it's got to be very, very, it's binding. I would say, I would argue it's binding precedent because it's dead on point, but for a permanent injunction. So anyway, going to be super exciting, and I think everybody should be watching this.
All right. Well, and that's going to wrap us up for another edition of Fire Law Roundup. We'll see you again next week.